Bruce Rivers, he's the criminal lawyer. But who is he? Bruce Rivers, he's the criminal lawyer. And who is he? Bruce Rivers, he's the criminal lawyer. And what he do? And it's gonna react to all the self-snitching.
Hi, this is Bruce Rivers. Welcome to another episode of Criminal Lawyer Reacts. I'm Bruce Rivers, board-certified criminal defense lawyer. Today we're reacting to the accused child killer. Oh, that just sounds so terrible. Letecia Stauch, accused of flipping off a witness during her testimony. Gee, that goes over well with the juror, doesn't it? But before we get to that, we're brought to you by eSign.com. eSign.com is a very effective way to remotely do business. For example, let's say a judge admonishes you and you hate your lawyer so much you got to get a new one, but you're in custody and you can't do anything about it except for you need to sign a new retainer agreement. Well, you can do it by e-sign if they email the jail staff there, because who's going to want to work with you and see you in person anyway? So what you do is you download the app, you get 3 free signatures a month, and then you send the retainer agreement to the jail and done. I use it all the time, especially when I either want to do something quickly and seal a deal, or if you just can't get it done in person. So eSign.com. eSign.com. If it's not eSign, no one signs. eSign.com, an effective way to remotely do business. So this ought to be comical. I do like kind of outrageous things that happen in court. So let's just check this out.
Mr. Allen, I'm going to direct this question to you because you made the comments on Friday. You had indicated that you had received some information, and I thought you said some photographs regarding the defendant's conduct, which potentially could be construed as extending the...
One of the things, some of this stuff could, 20 years ago wasn't happening because we didn't have cameras all over the place like we do now. And with cameras in the courtroom, it misses nothing.
Finger or flipping people off, including a witness, perhaps family. Do you have those photographs?
I can get them printed. Basically, it was just screen captures from what was being broadcast on WebEx, which I think the court may also have the same things that I saw.
Do we have that now? Okay, so we will upload some of that so that they're.
And I don't know what that does. I mean, we'll figure out what the judge does here in a minute. But think about that. You're having a trial, and you get this from the defendant to a witness, and one could argue that it's the defense error, right? Not error, but misconduct. So it certainly doesn't play well with a jury, for sure.
Some record of what it was. You may have all noticed that the tables have been slightly reconfigured. They'll be reconfigured again after or at lunchtime, largely because I think that table where it is generally wasted space. So what we're going to do is give you a more narrow one and slide that table over further. I'll move that table then to the back so that you can put stuff on it. You may still be able to use it to some extent, but nobody will be able to sit at it. Ms. Stauch, you have the right and obligation to be present for your trial. Being present permits you to see the evidence the prosecution is presenting against you. It permits you to communicate with your lawyers.
So basically where he's going with this is you have the right to be present at all critical stages of the proceedings. And when you're in trial, that certainly is a critical stage. However, if your conduct causes disruption and it's ongoing, the judge can remove you from the courtroom. We saw that in the Darrell Brooks case.
While that is going on, and assist them in your defense. You also have the right for the jury not to see you in restraints that are commonly associated with being held in custody or confinement.
So that's a constitutional right. You have the right when you have a trial, if you're in custody, to street clothes and not be shackled.
That way, the jury does not see you as a prisoner or someone who is in custody and is not prejudiced against you because of that. These rights, however, are not without limitation. While you have the right to be present for your trial, you also have the responsibility to behave with the respect and decorum required for this formal proceeding. You also have the responsibility to behave in such a fashion as to make the use of additional restraints unnecessary. Sometimes, during trial, a defendant chooses to act out. The likelihood that that will happen, in my experience, seems to increase the longer the trial takes and the more serious the charges are. And I know that right now we're in week 4, or we finished 4 weeks. We're starting week.
4 weeks is an awfully long trial. But remember when we saw the Darrell Brooks case, all the crap that he pulled, and they made him sit in another room. He still was able to see and participate, but in a much more limited fashion, and he couldn't interrupt the judge, and he couldn't disrupt the proceedings as much.
5. You aren't the first defendant to act out. Probably not going to be the last. I cannot imagine the pressure a defendant feels during any trial. It's not
especially if you're a child killer.
For a defendant to disagree with certain testimony or dislike a witness or a victim. Nevertheless, you cannot act disrespectfully in words or actions. First of all, never helps you out. You've already heard one juror submitted a question regarding his observation of your conduct. They don't miss anything.
Yeah. What do you think flipping off a witness does to a juror? I mean, it's like, okay, you want to give the best impression that you can. Unless you're going downhill and you don't really give a shit, so you just do this. I don't understand the benefit of that, but, then again, there's a reason she's sitting in that chair.
It makes your attorney's job much harder. They need to focus on the evidence presented and how to counter that, rather than your conduct in the courtroom. I am also aware of the practical realities that exist in this case. I could hold you in contempt for your conduct in the courtroom.
But what is the remedy for contempt? Just putting her in jail and she's already there.
Mean that I could impose a sentence of up to 6 months of jail for each incident of conduct which I find to be contemptuous. However, in a case where a defendant is facing decades or even life in prison if convicted, a 6-month contempt sentence does not seem to be much of a deterrent. But that does not leave me without a remedy. We have moved the tables around. You are now sitting in a chair that does not rock or swivel. You will be directly facing the bench, and you will be more in my line of sight. I want to caution you against certain actions, such as waving your hands around, trying to stretch your fingers out, and leaving one of them more prominent than the other. Those acts would be, in my opinion, disrespectful to the proceeding. It's disrespectful to the court and the legal process. I also view it as a form of witness intimidation and an attempt to influence presentation of evidence in this case. If that conduct occurs again, it would be a violation of the decorum I expect in this case. Everybody that's sitting in the gallery.
And when you have a client that's a pain in the ass like this, you just really want the thing to just get over with. And it does impact how it's not supposed to impact your diligence, but you can't help but have some deleterious effect on the communication between you and your client.
Them of the same kind of conduct. You can't do it either. I may then impose other remedies. I could simply have a bolt installed on the underside of the table and have your hands cuffed to that bolt. You wouldn't be able to use your hands. The jury wouldn't be able to see the handcuffs.
I had a trial not that long ago where my client, one of the charges from another case that he got while he was waiting a murder trial was escape. And so they put a leg brace on him so that it would lock in place so he couldn't run.
Be uncomfortable. I could have you removed from the courtroom and the trial would proceed without you. You would not be returned to the jail. Instead, you would be held in a holding cell in this building. You know how uncomfortable they are. You would then be transported back to the courtroom at every break to see if you had changed your mind and agreed to behave in a respectful manner a courtroom requires. And you would be brought over for the next day of trial, and we would start all over again.
You know, anybody that would put their hands on a child in a way like that would cause their death is somebody that's probably got a screw loose and doesn't give a shit about the proceedings that are ongoing. And so this is just an example of what the remedies are available to the court when a defendant acts up. And you heard what he said. He could, tie your hands to the table. He could bar you from the courtroom. He could have you in another room that has video hookup like they did in the Brooks case. So if it weren't for stupid decisions, drugs and alcohol, people like me wouldn't have a job. But the human condition is such that we are all imperfect, but some people are more imperfect than others. Not sure where her case is going, but it doesn't look like it's going too well if she's flipping off witnesses. That's a long trial. So I'm Bruce Rivers. Make sure you subscribe, follow us on Instagram, follow us on Twitter, sign up for Patreon, and because we're going to start a process. You get a free hat, and we also we're going to start doing Saturday kind of meet and greets. You got a question for a lawyer? You can do it for free on Patreon. We'll see you next time here on Criminal Lawyer Reacts.
Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. 23-hour lockdown, police is at my god.